Hello, and welcome to the HR Learning Podcast. My name is Heidi Macomber, and I'm sharing with you the things I love, anything having to do with employment law and human resources. As I read, you read. Today's post is about an NLRB Backpay settlement signed January 10, 2020 with CNN, one of the largest monetary remedies ever signed by the board. It's been 12 years from an initial administrative law judge finding in 2008 that CNN violated the NLRA, to an NLRB agreement and order in 2014, to a 2017 D.C. Court of Appeals ruling that asked the NLRB for further clarification on the joint employer and back pay findings. Finally, through the board's alternative dispute resolution program, there is a whopper of a settlement that may impact as many as 300 individuals. The following is a word-for-word reading of the January 10, 2020 National Labor Relations Board's notice. Settlement is the largest monetary remedy in the history of the NLRB. As part of a settlement signed today, CNN has agreed to pay $76 million in back pay, the largest monetary remedy in the history of the National Labor Relations Board. The back pay amount, larger than what the agency collects on average in a typical year, is expected to benefit over 300 individuals. The dispute originated in 2003 when CNN terminated a contract with Team Video Services, TVS, a company that had been providing CNN video services in Washington, D.C. and New York City. After terminating the contract, CNN hired new employees to perform the same work without recognizing or bargaining with the two unions that had represented the TVS employees. CNN sought to operate as a non-union workplace and conveyed to the workers that their prior employment with TVS and union affiliation disqualified them from employment. After a lengthy hearing in 2008, an administrative law judge found that CNN's actions violated the National Labor Relations Act, and that CNN was a successor to and joint employer with TVS. In 2014, the National Labor Relations Board agreed and ordered CNN to bargain with the unions and provide back pay. Later, in 2017, a panel of the D.C. Circuit Court of Appeals, including Judge Merrick Garland and then Judge Brett Kavanaugh, adopted the majority of the board's findings and enforced the board's order that CNN cease and desist from refusing to recognize and bargain with the unions. However, the court remanded the board's joint employer finding for further clarification, along with the issue of back pay for further consideration by the board. After the case was remanded, the parties agreed to resolve their dispute through the board's alternative dispute resolution program. Since then, numerous board staff have worked diligently with all concerned parties to reach today's settlement. General Counsel Peter B. Robb noted that the settlement demonstrates the board's continued commitment to enforcing the law and ensuring employees who were treated unfairly obtain the monetary relief ordered by the board. The parties are the National Labor Relations Board, CNN America, Inc., and Local 11 and Local 31 of the National Association of Broadcast Employees and Technicians, the NABET. Communications Workers of America, CWA, AFL-CIO. Established in 1935, the National Labor Relations Board is an independent federal agency that protects employees, employers, and unions from unfair labor practices and protects the right of private sector employees to join together, with or without a union, to improve wages, benefits, and working conditions. The NLRB conducts hundreds of workplace elections and investigates thousands of unfair labor practice charges each year. If you look on my post in the resources section, I have a link to the amended 2020 board decision for CNN, the standard for determining joint employer status, and then a link for the notice of proposed rulemaking regarding the definition of joint employer that was published in the Federal Register on September 14, 2018. I'm going to read a few notes from the NLRB Fact Sheet proposed rule regarding the standard for determining joint employer status, just to add to the notes. Overview. The National Labor Relations Board, NLRB, proposed rule would change the standard for determining whether one employer can be found to be a joint employer of another employer's employees. At a glance, the proposed rule reflects a return to the previously long-standing standard that an employer may be considered a joint employer of another employer's employees only if the two employers share or co-determine the employee's essential terms and conditions of employment, such as hiring, firing, discipline, supervision, and direction. The intent of the proposed rule is to foster predictability and consistency regarding determinations of joint employer status in a variety of business relationships, thereby promoting labor management stability. In 2015, there has been instability in the law regarding whether a company shares or co-determines the essential terms and conditions of another employer's employees when it indirectly influences those terms and conditions, has never invoked a contractual reservation of authority to set them, or has exercised authority that is merely limited and routine, such as by instructing employees where and when to perform work, but not how to perform it. The change to current law that would be effectuated by the proposed rule, should it become final after notice and comment, would be that a company could no longer be deemed to be a joint employer of another employer's workers based solely on its indirect influence, a contractual reservation of authority that the company has never exercised, or its exercise of only limited and routine authority. Under the National Labor Relations Act, the legal consequences of a joint employer finding are significant. The board may compel a joint employer to bargain over the terms and conditions of employees employed by another employer. Also, each company comprising the joint employer may be found jointly and severally liable for the other's unfair labor practices. And a finding of joint employer status may determine whether picketing directed at a particular business is primary and lawful or secondary and unlawful. The proposed rule reflects the board's initial view, subject to potential revision in response to comments, that the Act's purposes would not be furthered by drawing into a collective bargaining relationship or exposing to joint and several liability the business partner of an employer where the business partner does not actively participate in decisions setting the employee's wages, benefits, and other essential terms and conditions of employment. Thanks again for listening to the HR Learning Podcast. Copyright HeidiMacomber.com, all rights reserved.